Is there more than one document? Yeah, print them for me, please. All right, good morning, everyone. The court will call State of Wisconsin versus Jessy Kurczewski, 21 CF 885. May I have the appearances, please?
Good morning, Judge Abby Nikolai, Randy Sitzberger, and J.J. Crawford appearing on behalf of the state.
Good morning, Your Honor. Donna Kukler, Pablo Galaviz appear with Ms. Kurczewski. Good morning.
Court set aside this morning to go through the outstanding issues. There are a number of motions and requests that have been filed with the court. The defense had filed a number of requests last week, one of which I already dealt with. Then that was the jail attire or the attire issue we took up last week. Then there was the motion for a witness to appear by Zoom, motion for leave to amend the witness list, motion to preclude references to suspicious transactions. There was a letter request from the state that I did not address. Following that, there was, though, a motion from the state related to precluding specific televised testimony. Then there's some documents in opposition to the defense requests. One other motion that we somewhat addressed last week as well, and the jail was here, and that was motion regarding access to discovery. So I'm not addressing that one. I'm just sort of referencing what has been filed. And then I have some defense responses to the motion to preclude specific testimony. And then, I guess late yesterday, a request from the state related to motion in limine number 12 by the defense. This had to do with prior convictions for witnesses. So thank you for catching that. Obviously, we didn't address that back in February because of the adjournment, and so that is an issue we'll have to address as well. I did not see any opposition to the request to amend the witness list. Is that right?
That's correct, Your Honor.
All right, then that motion is granted without further argument from either party. Madam Clerk, that's document 240 that's been granted. I'll hand you that. All right, then we'll just take up the other defense motions. I can either have you argue them all one at at the same time or one at a time, and we can go back and forth. Doesn't matter to me. Do you have a preference, Attorney Kukler? And will you be handling those?
I will.
Okay.
We could do them one at a time.
Sure. All right. Let's start with the request to preclude reference to suspicious transactions. Now, I'm going to guess there might be some police reports that have this phrase in them. Is that why this motion has been brought?
Yes, there's police reports that have that phrase in it, and also possibly a ledger sheet that was prepared as an exhibit by the state that I anticipate that they're going to introduce at trial. And it's full, page after page after page, of references to suspicious transactions. And it's our position that whether a transaction is suspicious or not is an ultimate decision for this jury to make, and not for the state to comment on again and again and again and again, page after page after page, of talking about things being suspicious.
Don't we allow, though, for example, in an OWI trial, a police officer to say, I suspected that the driver was impaired for a variety of reasons, even in a trial, and have them testify about that, and the ultimate issue being whether the driver was impaired? And by analogy here, the question for the jury is whether any of these transactions are thefts. That's the charges related to those transactions.
I think that you're right. In OWIs, that's sure the case, but we're not in an OWI trial here. And this is a situation where the state has prepared ledgers that's filled page after page after page with the biggest part of every line says suspicious transaction on it. And so it's just the quantity of references. It's one thing for an officer in an OWI to say, oh, I found something suspicious, and he moves on then to the particular observations that he makes. And the observations are, of course, the officers can talk about the observations on these transactions, but to call them one after one after one suspicious and to put up big charts with these words on it, we feel is an ultimate question of fact and improper.
Are there any, lay witnesses or maybe someone from a bank or even a family member who noticed these things that you are requesting this, or just really the investigators and the state in asking the questions?
Well, the state's the one that's going to be introducing all of, for the most part, anyone from a bank or a credit card about particular transactions that they're wanting to show here that are improper or illegal. So I don't really know how many of those sorts of witnesses are going to be talking about it. I really don't.
I guess that really didn't answer my question, though. I mean, it's one thing if there's a family member that says, I'm concerned about this. They go to the bank, or even a bank representative saying to law enforcement, we consider these to be concerning or suspicious or even fraud. None of those things would be the ultimate issue, because frankly the ultimate issue is whether a theft occurred. So I just want to make sure that I understand the request.
I think there are some lay people. I think the state will be introducing a couple witnesses, that one in particular who was potentially going to inherit in the case, and relatives of that person that will talk about things being suspicious.
And you're not asking that be curtailed. That's what I'm trying to get at. As I understand your request, it's really the investigators looking into this, and if there is a chart during the evidentiary phase.
I'm asking that everyone be precluded from saying suspicious transactions.
Then what's your recommendation, or how do they convey to the jury that they had a concern? Is it, I thought they were illegal, I thought it was fraud, I thought it was suspicious? I mean, from my perspective, fraud would be a lot harsher than suspicious. I mean, a lot of things can be suspicious for a variety of things that wouldn't rise to the level of being a theft. For example, You know, if any one of us has probably traveled to another state, and if you start using your debit or credit card, you're going to get that call from the fraud department of your banking institution. They're doing their due diligence, say, we're a little concerned, these are suspicious, we're concerned they're fraudulent. You say, nope, I made all of these. So, I mean, this is some common vernacular, I think, that's just part of our everyday life nowadays. So how do I balance that out? And if I preclude anyone from saying suspicious, what do they say?
I think that, that's a good point that the court makes. I would say that the biggest concern we have really is with this massive chart that's going to be produced and shown in court that has got line after line, and the biggest part of every line is suspicious transaction. So, at a minimum, that we would ask that be blacked out. They can talk about these are the transactions we reviewed, these were ones we were concerned about, we looked into them, but the word suspicious again and again and again
Might be prejudicial.
I think it's overly prejudicial, yes.
I presume once we get to closings, if they want to use a chart and if that's what they want to label it and argue to the jury, there would be no objection to that.
That's true.
All right, what's the state's response then?
Yeah, I think you've hit it on the head, a lot of the terms that we're talking about here. I think suspicious, as laid out in our motion opposing this, it's a relatively tame version of events to describe these transactions. As we noted, we could have labeled these as criminal or fraudulent, and as you noted correctly, in our opinion, all of these transactions, it's whether they amount to theft, not whether or not they're suspicious in nature. So that, I don't think that goes to the ultimate question here. Additionally, frankly, the state I'd be asking the defense what exhibit she's actually talking about that lists all these suspicious transactions that we're talking about, because we're trying to rack our brains about that and we don't have anything off the top of our head.
You don't have some type of compilation or summary exhibit or chart that you plan to use?
Not with the word suspicious transaction.
Not with suspicious transactions labeled and everything. And if we do, I think that's something going forward we can address at the time of introducing that exhibit, not a blanket statement for all these witnesses.
So obviously, I don't know all the evidence, right? Haven't heard it, haven't seen it yet. The parties are intimately familiar with it. I can envision a number of scenarios where a witness might use the word suspicious transaction. I am concerned about getting to the point where it's over and over and over again. I think when we get to that repetition, there is a concern and whether it's unfairly prejudicial. And Attorney Kukler corrected me because she said, well, I think it's unfairly prejudicial because that's the standard. I mean, all sorts of evidence can be prejudicial. We know that. It's whether there's unfair prejudice to the defendant. So just give me just a very brief offer of proof as to how many witnesses you think we're talking about, and whether there's, my concern for cumulative reference to suspicious is founded at all.
Judge, just because they're mostly my witnesses, I'll give the offer of proof, even though Attorney Crawford is arguing this, if that's okay with everyone.
Sure, go ahead.
So I believe Anthony Poza will reference that he asked Ms. Kurczewski at some point for receipts related to the probate, as he's put it to me, because he felt something was off. He's never used the exact term suspicious, but as a means of explaining why he even asked for receipts, he describes it as just feeling something wasn't right or something was off. Attorney Beth Taylor, who's been doing probate work for 25 years, is going to testify that when she looked at the final account statement on that probate account, she saw it as a red flag that a 67-year-old woman would have $100,000 plus of credit card debt. She doesn't see that ever, if not very seldom, in her 25-year career. And then it'll be Detective Plennis primarily going through all the financial statements, really talking about the patterns of life between Lynn Hernan and Ms. Kurczewski and how those were fairly different from one another, both geographically, spending-wise, as well as amounts spent and things of that nature and frequency of credit card use. I don't know that he and I will ever really get into a back and forth about this is a suspicious transaction and this is a suspicious. I don't think we're going to belabor any points. I think that may come up organically in terms of why he was paying attention to these types of transactions, but I don't think it's going to be something that's belabored where he and I are just filling the court transcript up with the term suspicious transactions. But I think we should have the freedom to describe, primarily through Detective Plennis, that this is what he's looking for in his investigation as a detective, is for suspicious things. Ms. Kurczewski was a suspect, and so we are looking for suspicious things. Alternatively, I don't know what a detective is supposed to say aside from, I was just looking at numbers and here's what I have.
Were you planning at all in your opening statement to describe these as suspicious transaction? And if so, is it a one or two time reference, or were you going to dig into that?
In my opening, I really talked mostly about how we were going to prove that these are thefts and not simply suspicious transactions, but that we are going to prove that Ms. Kurczewski stole this money from both Lynn Hernan and then later her estate. I'll say right now, just because it might come up, there's several references to the lies that we are going to prove were lies on the part of Ms. Kurczewski. That is, I would say, the bulk of my opening statement. But the word suspicious transaction is not one time in my opening PowerPoint, nor do I intend on, again, belaboring that specific quotation.
Attorney Kukler, because you brought this motion, is there a particular witness, a police report, or some other piece of evidence that this phrase, you reviewed and that's why you filed the motion, or was it just generally your belief that this was how the state would refer to these transactions?
Thank you. No, it was because I believe that Detective Plennis was going to introduce a chart that was in discovery that is filled with a chart that we received from the state, a ledger, a spreadsheet, I guess it would be the best word for it. It's a spreadsheet, and it's filled with line after line after line of the word suspicious transaction. If the state's indicating that they don't have any such exhibit that they're planning to introduce, then problem solved. But I assumed it was going to be used.
Understood. All right. Attorney Sitzberger?
Judge, I don't believe any of our exhibits that we turned over to defense yesterday on the flash drive have anything labeled as suspicious transaction. In some of the earliest discovery, there was an Excel spreadsheet with the original detective sort of summary of the accounts very early on that may have said that, but if the defense can point to a specific exhibit number that we've turned over, I'll certainly take a look at it, but conferring with the entire team, we do not believe any of our trial exhibits label anything, quote, a suspicious transaction.
All right, thank you.
And obviously, Judge, the flash drive was turned over yesterday and our motion was filed in advance of yesterday.
Understood. Obviously, review that. I mean, it's the actual exhibits based on what's in discovery, so I understand why the defense raised this issue. But given the offer of proof from the state and the arguments, I'm going to deny the motion. I will say this. I think similar to an OWI case, Detective Plennis, if he, in his review, considers these to be, if he renders an opinion, let's say, no different than an officer in an OWI case, that there was a concern, overall for theft, for suspicious transactions, I think that's fine. I will leave it to the defense if it becomes cumulative to raise an objection. That would be my concern as well. But given what I've heard from the state, that would be, I guess, fair game. It's not going to be overly or unfairly prejudicial to have even lay witnesses talk about things, that something was off, there were red flags, there was a concern. I think all of that is fair game. And if for some reason there is this chart and it materializes, or there's a change in game plan to use an Excel spreadsheet that was in discovery, then of course I'll revisit this. But given what has been stated here today and the arguments, I'll deny that request. Do you want that document, Madam Clerk? That's the 242. All right, then let's take up the motion related to the witness and the request that the witness appear by Zoom. Attorney Kukler, will you be handling this one as well?
Yes, I will be. I think that it's self-explanatory, really. We're asking that one witness be allowed to testify by Zoom. I know I've read the state's objection to it. I would comment that there I understand that they object to it. However, I've had certainly many trials, and just had one 3 weeks ago where we had several physicians testify by Zoom. It went very well. We didn't have any problem. It was a courtroom similar to this with new technology where we could share screens.
Is it a civil or criminal case?
It was a criminal case in St. Croix County with Judge Waterman, and he allowed witnesses to testify by Zoom if they needed to, if they had good reasons, like their health or where they were located. He allowed it.
Did he do any type of instruction to the jury, given the technology?
He did. He did tell the jury every time one was testifying that they were to consider their testimony the same as if they were in the room, that they weren't to give it less or more weight, especially because one of the TVs was large. So they weren't to consider that to be more significant than a person that would be in the courtroom. But he did that each time.
Did any of the witnesses need to be questioned about medical records or documents, and if so, how was that addressed?
So yes, they were, everyone, and we were able to. They had the ability in that courtroom to give us the ability to share our screen. So they would release the screen to us. We could share the screen, whichever attorney was doing the questioning, and it worked fine.
We have that ability.
Okay.
I've done that before.
So this doctor has asked for that consideration. I'm making a request on her behalf.
And where would she testify from if I allow this?
She would testify from her office.
And have you been able to confirm if that's private, meaning she can close the door, no one else would have access?
I didn't confirm it, but I can make sure and instruct the witness, as we did in this last trial, that they were to be in a private room with no one else present.
All right, and who will be arguing this for the state?
I will, Your Honor.
Go ahead.
Your Honor, as noted in our response here to the defense's motion, I just think that there's too many variables here for this to go forward via Zoom. Mainly, these are a lot of medical records here that are going to be involved. Obviously, we'll be able to pull them up for her potentially, but depending on her location and situation, she could have notes that might be on the side to verify what's actually in front of her could be a problem. I would also note that I think the biggest thing for the state here is the fact that the doctor here is still seeing patients regularly. She's going into work to do this. She's going to church. She's going to the grocery store. She's doing all these things, living a relatively normal life, still wearing a mask and all that. That's no issues. The state would have no issues with that precaution being taken. But it's our position that coming in and testifying, it's not like all these people are going to be coming in here and trying to spread germs to her. There's no different than going to a crowded church or a crowded grocery store. Those are all places that have a lot of people. This is not like the doctor here has ceased going to the outside world or anything like that. So for all the reasons of the complications, I understand that technology is obviously taking a step forward and we're not living in archaic time here in that regard. But just given the potential for a blow up or something going haywire in that regard, as well as the other issues that I've already addressed, the state would be in opposition here.
Attorney Kukler, as I understand this witness, this is someone who treated the victim at one point.
Correct.
And your direct of that witness, how long do you estimate that will take?
No more than 2 hours.
So fairly detailed in terms of the testimony you hope to elicit.
I'd say no more than 2 hours.
Okay, but what I'm getting at, this isn't just a 5 or 10 minute witness.
No.
Okay. And how long does the state believe their cross will take?
Your Honor, at this point, the state can't give you a number.
You reference the medical records on cross-examination. Are these her own? I mean, the medical records this doctor was part of generating through the course of treatment?
Yes.
Or other medical records that you want to confirm maybe that she's not aware of or something like that?
No, it would be the ones that she helped generate.
So presumably she would have all of those because they're electronic, right?
Correct.
So the statute this court must consider is 807.13. And obviously the defense has made this request. There's an objection by the state. The court can allow such testimony if I find there is good cause for allowing it. And I think good cause can be based on for a variety of reasons. Certainly the health of an individual is something this court needs to be mindful of. A person's compromised immunity would fall underneath that. I'm not at all concerned about the technology. This courtroom was built for these opportunities. I have done everything from having witnesses. We did motion hearings with experts in this particular case last December. I have routinely taken pleas in very serious felony matters by video. I've had victims afforded the opportunity to appear by video. And I don't think it is necessarily my place to second guess this doctor's comfort level in coming to a public building in a courtroom. While I believe that we operate very safely, I've done many, many trials through the pandemic, during, after, and we have done so safely. We take the utmost care and concern for our jurors, for our witnesses. But the fact remains there are people who do not feel comfortable coming into a public place where there is high volume of traffic. Even though this witness stand is pretty isolated, I'm not within 6 feet. They might be within 6 feet of our court reporter, and our jurors would be more than 6 feet away. And I'm obviously referencing 6 feet because that is something we did during the pandemic, and I think even that bubble, if you will, has reduced a bit over time. But she has raised a request through the defense team, Dr. Sema, that is, and although she's seeing patients, I don't have a lot of information. I don't know what other precautions that she takes. I don't know if she sees them by video or not. But I believe that the defense has sufficiently shown that there's good cause based upon the health concerns and the compromised immunity for Dr. Sema to testify by Zoom. I would ask Attorney Kukler that you forward to this court by way of email the language that Judge Waterman used in his case that you were a part of in St. Croix County. I will make available, since this will be by Zoom, Each party should bring a computer that can connect to the Zoom so that if you want to share the screen and cross-examine based upon medical records, I will do everything in my power prior to the witness taking the stand and outside the presence of the jury, we will do just a brief colloquy. I will do a brief colloquy with her just to assure that she's in a private room. There's a door, that no one will interrupt her. We will ask her what she has in front of her, what she has access to. If there's a request that she not have access to her electronic records, then I'll take that up at that time or shortly before she testifies. And I would ask, though, that and require that she have the ability to share her screen as well, if in fact she does access something and so that the parties can see it. Now, I realize in a normal way of doing things in the courtroom, that's not on the television, right? And so there's been a request, and so we'll have to think about how we protect the privacy of those records as they relate to the victim. No one's really raised that here today. I know that I can turn off the monitors so that for the time being, only the parties would see it and the court, so that the jurors are not. Obviously, if these are records that you all plan on being part of the file in any event, it may be, as we get closer to this witness, that it's more appropriate. I don't know how long her records are, but it might be more appropriate to have them printed off, since it's her request to testify by Zoom. Then it may also be appropriate, and I would order this, that she print off and have a printed copy and provide a copy to the state and to the defense. That way, I am also protecting the privacy of those medical records, and they're not being streamed, worldwide. I kind of, as you can tell, this is sort of stream of consciousness, but that just kind of came to me. I thought about it. I'm like, I need to be concerned about that. And so I think what I will do is what I've just outlined is require her to print off all of the records related to Lynn Hernan and to provide copies of that. Yes, do we have them?
We have them. The state has them. They
Okay.
provided them to us.
But there could be something we're not aware of. And so I think in preparation for her testimony, you will need to be in communication with her and confirm that those are the only records she has related to the victim.
Okay.
And then I guess I can dispense with the, I just want to make sure that what she's reviewing, you all have, because that's important. Again, we'll allow the share screen. That's not a problem. We'll just have to think about, I may have to make some rulings ahead of time to the media about not showing the share screen. Keep in mind, it's the jurors would still see it, and even if it's on here, they can take precautions to keep the camera on me or the attorney who's questioning or something like that. So just be thinking about that, and we'll revisit it as we get closer to her testimony. And I will give an instruction before this witness testifies. I'll trust Attorney Kukler will get me that language. I may reach out to Judge Waterman as well, and just, he may have, I'm hoping he has a Word document, and then I can share it with everyone. So I'll do that. Did he do anything else with final instructions regarding that, or just did it at the time of these witnesses?
No, I don't think he did it at the final. But if you're reaching out to him, you can ask. I think only as each one testified.
Any other precautions that he took that I should consider?
No.
Just that brief, I'll call it a cautionary instruction, that's what we would call it, to the jury ahead of time.
Yes.
And then, of course, already addressed how we'll deal with, we'll utilize the Zoom, we'll utilize the share screen. I'll give access to the parties during cross to do that. And then I will just have to either enter an order or modify my trial administration or just give them a verbal order to the media who's covering that they not broadcast those records. All right, Madam Clerk, so that's 246 document number. Okay. Were there any? Oh, I was probably looking at the states. Yeah, sorry. Any other requests from the defense?
No, nothing on motions. It was my recollection that we had decided if prior to the jury trial each day that we were going to get a few minutes with Ms. Kurczewski. Do I remember that correctly? That you were going to try to have her brought here a little early, and that
She should be here by 8:15 each day. So if you're here by 8:15, then she will be made available.
okay, great. It did, because she wasn't today.
And today we started at 9, and I know there's other things going on, and I may have thrown them off. It's frankly easier for them, I'm told, the earlier it is than later. So, but I was assured that they would do their very best. Obviously, things can be fluid, and sometimes there's situations in the jail that are out of all of our control that might prevent that. But I think they will do everything that they can to get her here between 8 and 8:15.
Okay, thank you. That's perfect. Nothing else.
Okay. All right, then let's turn to the state's requests. We'll be arguing the request about the testimony and whether it be televised.
I will as well.
Just a note on that, it was not filed under seal. And so if I don't have a request, and if you all don't take the steps to file it as a sealed document, there's nothing I can do. And so I know it's been reported on in the media already, so just so everyone's clear, that was not filed under seal, and it's not under seal at the moment.
I know we attempted to use the temporary seal function on our end. I don't know what happened in that regard, but understood.
All right, go ahead.
Frankly, Your Honor, I think a lot of our concerns are addressed in our motion here. Ultimately, we're not trying to intervene with Ms. Kurczewski's, freedom to have a public trial or anything like that. But our doctors here, as evidenced by our meeting with Dr. B late on Thursday last week, so after that Wednesday motion deadline, she continued to raise concerns to us essentially about the nature of this drug, the prevalence of this drug, and I know that the defense is probably going to disagree with this terminology, but essentially creating a how to kill playbook here. As noted in our motion, this drug is odorless, tasteless. There's very discrete means in which this is given. Actually, there are hospitals have issues with they don't even test for this drug. Certain labs across the country don't test for it. It's a very difficult thing to actually test for, and you have to specifically ask for it at a lot of labs. And frankly, the doctors here came to us and brought up their ethical obligation here to ensure that at least we made the request to the court that we don't amplify this testimony here. We understand that they're going to be reported on in the Journal Sentinel, you name it, whatever newspaper outlet. Anyone who wants to, they can come in court and watch and report on it live if they want to, but we don't want to give this out to the masses even more than it possibly can already. And again, we're not interfering with anyone who wants to come in here in an open courtroom and watch it personally, or follow a live blog or what have you. They could, even if they want, they could order the transcripts from the testimony of the doctors. But we just don't want to make this easily accessible that can be gone back to time and time again for somebody that might have nefarious reasons to do so. So that's the basis for our request here, Your Honor.
Have you done any type of search on the internet to see how prevalent information is outside the medical community and the concerns raised by Dr. Bidzricki and Dr. Kacinko?
I think a lot of them have to do with that there are occasional cases that are criminal cases that are now popping up with this drug, and just the context behind that. We don't have any, I guess, independent knowledge or internet history about this blowing up on certain forums or anything like that.
Aren't you really asking me to limit public access to this trial?
I would disagree with that. We've done trials for hundreds of years at this point in this country with before court TV. Like I said, we're not asking the court to deny access to anybody who wants to come in person and watch this, or journalists reporting on this. We just don't want the internet, there could be thousands of people watching this at any given moment and getting any ideas for any nefarious reasons.
But everything you've referenced thus far has already been discussed in this courtroom. We had motion hearings, Daubert hearings with these individuals who testified, perhaps not in as much detail, but this is not new information. I mean, poisoning someone by any substance, that's not new information. For God's sakes, you can go out on the internet and Google just about anything. You can learn how to make explosives. It's unfortunate, and I'm sure people follow those plans. And I'm just not so sure the information that you're seeking to protecting isn't already out there. And if you haven't done any search of the internet to even refute that, I think I have to assume that this information is well known and out there. So what says the defense?
Well, it is well known and out there. The state handed me a whole stack of papers yesterday that's new that they want to introduce through Dr. B of her research that she's done on the internet, of articles and newspaper articles, and a homicide in Aurora, Colorado, and one case after another that she's found on the internet that they handed me that they're hoping to be able to introduce. So it is well known out there, not only in their own documents that they handed to me just a day ago, but it's been on Dateline. It's on 2020. They've talked about tetrahydrozoline.
I mean, how is it any different, frankly, than the Mark Jensen case? Just a different substance that was televised fully with no restrictions.
No different.
How is it any different than that, Attorney Crawford?
Your Honor, I don't know if that the poison or what have you is necessarily different, or I frankly didn't really pay attention to the Mark Jensen trial. But I can tell you, the court, just from our jury selection even yesterday, we only had, 10 hands that actually knew about this drug or had heard of this case or anything like that. So I just don't think that we need to amplify the effect that this could possibly have. And I want to go back to your point earlier about the previous motion hearings. I wasn't on this case at that time, but it's my understanding that those motion hearings weren't broadcasted on court TV. So
no, they were live streamed.
Right, but
you can't watch them today. They were live streamed.
Who's watching the Wisconsin court access live streams as opposed to court TV? I just think there's a completely different audience that we're addressing here.
I disagree with that because they were live streamed and anyone in the world could watch those. I utilized the court streaming service, what we call Daycast, and so there's not a link to that anymore, but that was available to everyone. I'm going to deny this request. I see no reason to limit public access the way that the state is requesting me to do so. This is a case that's been televised. that's captured media attention really from the beginning. We did have the Daubert hearings where both Dr. Bidzricki and Dr. Kacinko testified. We also had Mr. Spiller testify as well, where, again, may not have been in depth because of the nature of those hearings, although they were pretty lengthy. And it may not be, what I'm trying to say is I anticipate that their testimony will be longer and more in depth. There's nothing, special about tetrahydrozoline poisoning and an allegation of it that would cause this court any concern. I appreciate that the folks in the medical profession feel they have an ethical obligation to, raise the issue. But this court has made a decision that it would be televised based upon the request that I received from Court TV. I would say almost all of the proceedings in this case have been televised, except for jury selection and, frankly, the motion hearing we had last week. But most of them have been, where all of these things have been discussed. Frankly, the criminal complaint has been reported on in detail. And so all of that is public. The Supreme Court rule that's cited by the state does not apply in this particular situation. The state acknowledges that. So I'm going to deny that request. Madam Clerk, that's document 247. Any other requests other than the letter that was filed regarding the prior convictions of witnesses?
The state does want to address briefly. Defense did provide us a copy of their exhibits, which we obviously appreciate. In that, there are a couple exhibits that we just want to make sure that are addressed ahead of time.
I'm not going to do that right now. I don't have anything in front of me. I'm not on notice. I don't even know what they are and haven't pulled them out. Let's talk about those, since it's not a new issue, even though the letter was filed yesterday. At least I have a question regarding the prior convictions. I know at one point, it's at least my recollection, that I ordered the parties to meet and confer ahead of the previously scheduled trial. I don't know if that ever happened because it ultimately was adjourned, but have the parties met and conferred regarding prior convictions for witnesses?
No.
All right, then before I take that up, I'm going to require the parties to meet and confer, and then you can limit, maybe there's stipulations, but you can limit the issues for the court. I don't need another filing on that. I'll certainly work off of the October 23 letter. Does the defense know if there's any other? Well, look at this list and make sure you tell me if there's someone not on the list that you believe needs to be addressed. What I would say is if there's concern about defense exhibits, obviously we have a whole state's case to present first. Please meet and confer. I expect the parties to do that. Even if you can't reach an agreement, sometimes clarification can be found, agreements can be reached, but I think it's important. I'm a big proponent of due process. You all know that. If the last 2 weeks haven't shown that, then no one's paying attention. So notice to the court and to the other side of the issues that you're asking me to address outside the presence of the jury and ahead of time. We need to follow those dictates. I understand that as things come up during the trial and there's objections, that's different, but this is ahead of time. And so I want to be the most prepared that I can be. And I've often found that if you meet and confer, that helps resolve the issues. I don't think there's anything else we need to do just yet this morning, but I'll ask the parties, is there anything else from the state?
No.
From the defense?
No, thank you.
All right, well, you will have lots of time this morning to meet and confer regarding the witnesses. It's 9:53. I'm having the jury report at noon. Oh, that reminds me, I do want to make a record. We were after court, juror number 29 indicated to the civilian jury bailiffs that he was not going to come. I've already taken steps that if he is not here at 12:05, they can go find him. This is an individual based upon the jury questionnaire that indicated they might have a hardship. I asked 4 very pointed questions at the end of jury selection where no one raised their hand. I give them every opportunity to raise an issue. I don't know why that person and juror number 27 didn't as well, but I take these things very seriously. I want you all to be aware of that so you can pay attention and watch these jurors. We'll just keep plugging along and address anything else that comes up. I'm just giving you this information. I'm not taking any steps at this time other than I'll make sure we have all 16 here when we begin. I'm going to bump up our start time to 12:30 so that we can go through the letter and the prior records of people so we can get that out of the way. So I'll be stepping off the bench. Obviously the cameras and the microphones will be off. If you all want to meet and confer and hash this out and have Ms. Kurczewski available for that, please do so. And we'll get that taken care of before we start, okay?
Could I raise an issue?
Sure.
Thank you. Are you going to say anything to jurors 27 and 29 today?
I haven't decided that yet. I am thinking about that. I may bring them in, just the 2 of them, and talk to them about how this is so important. This is their civic duty. They had every opportunity to raise that issue. They did not. I expect them to be here. And if for some reason we do not get a hold of juror number 29, I have some options available at that point. I wanted you all to have that information, and certainly I'm willing to talk to them as well. I want to kind of wait and see how it goes today. I mean, as they say, a day can make a difference, and maybe they just it's like their initial reaction, they're upset, but they realize, hey, this is important and I need to be here. So we'll just take a wait and see approach.
All right, thank you. And I wasn't sure whether the court swore in the jury yesterday.
Nope, I have to swear them in when they come in.
Okay. All right.
Yeah, I'll do that. I'm a little strategic on that. I wanted to make sure, but yeah, Teresa left me a very nice note. Have Teresa swear in jurors, so we have to do the second oath. All right, thank you everyone. We are in recess. We'll see you back here at 12:30.